May I start?
Just hold on, ma'am. We are going live. Good evening, friends, and thank you for joining us on behalf of Beyond Law CLC and Recurrent Associates. We welcome you to yet another engaging session by Ma'am Susheela, who is also the author of the book of Advocacy and Professionalism. So they say that if you hear something from a good speaker and you read that book, it's always a pleasure. And therefore, you have a double combination in the aspect that you can hear the bird-eye view of the advocacy and professionalism. And thereafter, you can also buy the book, which is worth reading. And all her earlier books on different perspectives of law have always been well appreciated and well received, including her sessions, which she has done, not only with Beyond Law CLC, but even otherwise. We are glad that she has accepted our invite. And as I told earlier, in the earlier session of Specific Relief Act, to the effect that ma'am had a fall, but her passion to pay back to the society. Is that what is moving on? I'll ask ma'am to take the things forward, and over to you, ma'am.
Thank you, Mr. Vikas. Sorry for the difficulties that we had due to technical glitches. Today I have chosen the topic advocacy and professionalism for two reasons. We see two categories of advocates. Advocates who are more qualified than us, more knowledgeable than us, but however, they are unable to make a mark in the profession. And we have also seen those advocates who are less qualified than us and may not be very, very highly intelligent, but still they have been very successful in the profession. Why has it happened is one thing that we need to understand. And another thing, this is my I have completed 40 years of my experience as an advocate. I'm a designated senior advocate from High Court of Karnataka. With my 40 years experience, I have seen probably in India, advocates are not so very financially, we could not make ourselves very, very affluent or whatever it may be from the perspective of financial success. That's one part of it. Of course, of late we have seen advocates are also earning very decent salaries if they have joined some firms, or if they are independent practitioners, they are also able to earn sufficiently. One thing that I have observed here is that advocacy and professionalism both should go hand in hand. If you want to be a successful advocate, then you have to take advocacy and professionalism together, is what I would like to suggest to young advocates. When we say what is professionalism, one part is that of professionalism is that you have to understand what exactly is professionalism. It's a combination of your competence, your integrity, your reliability, the respect that you command, the respect that you give to others, and your accountability and the responsibility that you take. That is, professionalism is a way of demonstrating your competence, integrity, respect, and responsibility in your role as a professional. When I say this, let us understand the key elements of professionalism. These are 6 key elements. One is your competence. When I say competence, we should work in improving our competence. We should have sufficient knowledge. We should also have soft skills. We should also know about techniques and skills associated with advocacy. Advocacy skills, advocacy techniques, and we should always try to work on ourselves. We need not have to compare with others, but we have to compare ourselves with ourselves, so that what I am today, tomorrow there should be an improvement in myself. This is what we have to do. So competence is the first key element. If you are not competent, you may not be successful. If you are not sufficiently competent, you have to work on yourself to see to it that you are considered as a competent person in a given field. This is one aspect. The second one is reliability. What is reliability? If you are a professional, then people should find yourself as dependable. You should meet deadlines. You should show up on time and you should follow up on commitments. Many of us will take so many cases and we may not be able to attend all those cases. We entrust it to others. They may not do the things which are expected to be done in a given manner, and we don't follow up on our commitments. These things may happen in our profession for various reasons. But if you want to prove your mettle, then you have to be completely reliable. That means people should find that yes, if I have engaged the services of Mr. or Mrs. So and so, we can rely upon that professional. That professional is dependable and they meet the deadlines. They show up on time. They don't miss on any of these things. So the first element is competence. The second element is reliability. The next one is integrity. I will deal with these aspects little later. We should not compromise on our ethical principles come whatever may. Even when nobody is watching, we should not compromise. Integrity is not compromising on ethical principle, whether somebody is watching us or not watching us. It is something, it's a commitment given by a professional to oneself, to one's own conscience, and to the superpower, whoever may be the higher principle, whatever may be the higher principle whom you believe. That's the next aspect. You are answerable only to your conscience. The next one is respect. We need to be respectful to others. Our profession demands, if you are a professional, the professional behavior requires something else, which is a behavior which is different from that of any other's behavior. The professional's behavior demands that you must be respectful to others. You must be respectful to the court, to your colleagues, clients, opponent clients, and whoever comes across you in your professional capacity. You must value their perspectives. You may not agree with them. You can always disagree with them. You may have serious disagreement with your opposing counsel or your client's opponent, but you must not be disrespectful to them. One thing that distinguishes you from others as a professional is your respectful behavior. Maintain this particular element in all walks of your professional life. Accountability is another thing. We do commit mistakes. At times we don't show up on time. At times we don't communicate properly. At times we communicate incorrectly. But we should take the responsibility. We should take the responsibility and we should tell them, look, I did this mistake and I am here to apologize and I am here to set the things right. Whenever some wrong submissions are made by us inadvertently or knowingly or somehow by mistake, we might have committed some mistakes. By all that you need to do is immediately go back to the court and respectfully submit, I own responsibility for this mistake has happened and permit me to correct this mistake. This is accountability. When the court finds you that you are accountable to your own conduct, then your value increases in the eye of the court. This is where we have to consider ourselves as professionals. Next one is communication. Many of us, in fact, I started my practice from the Mofussil area. We did not find it very, very important to communicate with the clients, but the times have changed. everything they want to be they expect us to communicate regularly. So I would suggest that as a professional, maintaining appropriate timely communication with courts and clients and others related is very very important. If you constantly keep the client informed, they feel satisfied. Ultimately, whatever be the result, end result, that's different. But what they expect is constant communication with them. It is not just with the client. You must also work on your communication skills. There are four communication skills which are very, very essential for an advocate to be successful professional. One is content. We must work so much on the content that we should not go wrong either on facts or on the legal propositions. And without there being any content, we should not speak at all. When the content that you have with you gets over, you should not speak. Do not do anything without there being any content. This is the first principle. The second one is clarity. What do you mean by clarity? When we communicate, the message sent by us and the message received by the court or anybody else should be the same. There should not be any chance for misinterpretation, or they should not there should not be any lacuna in our communication. The message sent and the message received must be the same. Clarity means, I'll give you an example. Supposing I say, ice is cold, fire is hot. These are statements where there is complete clarity. Nobody will question this. So, whenever we are articulating our thoughts and presenting our thoughts before the court, see to it that there is complete clarity. How do you bring that clarity is up to you. Where you should stop, where you should start. There should be pace, there should be pause. All these things, and how your voice modulation should be. All these things falls under the category of clarity. And continuity. When you are making your submissions before the Honorable Court, there should be continuity. If you have started with one particular aspect, continue it, bring it to an end, and go to the next topic. And it should not be scattered everywhere. This is another aspect. And the last one is brevity. A professional will never be appreciated if he goes on repeating whatever he wants to submit. Repetition is considered as a weakness of the professional. Brevity means you use measured words and chosen thoughts. Measured words and chosen thoughts. When an advocate uses measured words, chosen thoughts, he is respected more. This aspect we have to just practice on this. Talent is not to use two words where you can use one word. Now, how do we work on ourselves is something to be considered. I have chosen for this particular session, I have chosen 5 topics. One is time. As a professional, if we have to work on any particular resource, according to me, is time. Time is the most valuable resource. Where is our time going? Are we making use of our time efficiently, properly? Is the question that we have to ask ourselves. When I say time as one of the resources, you should not take up any assignment if you are not going to get any monetary compensation. I don't say that you should not be doing pro bono work. There are some components that we have to keep in mind if you are taking up any assignment. One is that if I take up this assignment, if I take up this case, am I going to be benefited monetarily? This is one question you need to ask. Number one. Let us keep that in a bracket. Monetary compensation, let us keep it in a bracket. The second one is, if I take this assignment, is it going to enhance my professional reputation? There may be some cases where you may not get monetary compensation. You may not be paid very well, but that particular cause for which you are working may take your professional reputation to the next higher level. Then, in spite of there being no monetary benefit from that assignment, you can devote your time for that professional cause. There may be a third category where there are assured future benefits. A client may come who may not pay you very well, but you are sure by fighting his case, or a lawyer might have referred you a case, you might have done that case on a pro bono basis without taking any fees from him. But that particular lawyer may get you some more clients, or that particular client may bring some other clients to you. So there is assured future benefits. Under those circumstances, also, you can take those assignments, though you are devoting so much of time. For example, I was a government advocate for more than 4 years. As a government advocate, what we earn, what is being paid to us was very less in those days. Even now, also, when it is compared to your private practice, what you would be getting will be very less. Notwithstanding that, you are assured of future benefits, because the knowledge that you get in your one term as a government advocate is something that's very, very, amazing knowledge you will get. That knowledge is a treasure island for you. With that, your future career, you can take it to a different level. So, if you have invested your time in that, there you may not get monetary compensation. Tomorrow itself, that day itself, or tomorrow itself, your professional reputation may not go to the next level, but you have assured future benefits. In such circumstances, you can invest your time. Personal fulfillment. There may be some causes for which we work. For example, in child custody matters, personally speaking, I feel a sense of fulfillment when I work for the cause of a child suffering from autism, or from some, if they're specially able children, then I work for them. I may not get any monetary compensation. It may not take my professional reputation from the place where I am to the next level. I am not assured of any future benefits by taking these assignments, but still it gives me a subjective satisfaction. That is personal fulfillment. When I have this, I can definitely devote my time. But if it doesn't fall under any of these categories, please question yourself, why am I taking this assignment? Because many a times clients feel that they are doing some help to you by giving their case to you. They should not be permitted or allowed to take advantage of your disadvantageous position. A professional should always have control over his profession. What do I do? Why do I do? For whom I do? These are three elementary questions a professional should ask before taking any assignment. If a client is draining you too much, draining your energy, and there is nothing, there may be so many files in your office which is not in any way beneficial to you, but it is draining your time, money, energy, and mental peace. Should we have those files in our office? Is the next question that we need to ask. In my book on professionalism and advocacy, I have taken 117 chapters. Each chapter deals with different aspects of our profession. So, time is something about which I would like to request you to concentrate more. We need to take periodic time audit. Where did my time go? Did I spend my time on wrong priorities? Did I spend my time with wrong people? How much of my time that I have spent today is productive? I would request all of you, particularly the youngsters, to practice journaling every day. before you go to sleep, answer these four questions. If you want to be successful, move with successful people. Otherwise, keep yourself alone. There is difference between loneliness and solitude. By avoiding by avoiding being with the company of persons with whom you should not be, you are not going to lose anything. If you want to be successful, be with successful people, observe what they are doing, how they are making use of their time, how they are working in a productive manner. These are the things that you have to understand. So periodic time audit is something which you should never compromise. The next thing that I would like to request is to work on giving attention to details. You have to give meticulous attention to details. It may be one amongst 100 cases in our office, but that is the only case of that particular individual. A case I had seen where the very contention was that so and so is not the son of so and so. So the parenthood was questioned. In a partition suit, when A filed a suit against BCD, BCD took up a contention that A is not born to so and so at all. But when they filed an appeal, they never said claiming to be the son of, but they also said son of. That was an admission. Repeatedly, their admission was that. So there was an error here. Why this error has happened is because of not paying attention to the details. So paying attention to minute details is something that is very important. Every brief is important. I would rather say that every brief should require your equal attention. It may be a small brief where you have been paid very less amount, but still the way in which you are attending to that particular case, giving your 100% attention to minute details, and you are taking it layer by layer, and doing everything that needs to be done in that case, then in that case you may not get any financial benefit to the extent of your inputs in that case, but it will definitely pay you at a later stage. You must also remember about small tasks that need attention. You may be very sound, very good on substantive law, but procedural law should also be taken into consideration. What needs to be done, when it needs to be done. If there is a time limit for something to be done, we have to do that. So, small tasks that need attention will have to be attended to. Clutter to be discarded. This is one area where we have to focus on. Justice Thakur was with us in Karnataka High Court. I remember once when Justice Thakur was there, his lordship said, "वो तो रद्दी है, उसे क्यों रखे हैं आपके ऑफिस में?" That which is not worth keeping, we need to send it. We should respectfully hand it over to the persons to whom it should reach. Let us not keep that which is clutter for us for various reasons. And even while drafting, even while drafting, be it pleadings of any kind or communication, see whether there is any clutter. If there is clutter, remove it, discard it, and then your presentation, even your synopsis, if there is clutter, to be seen. When we pay attention to details, our synopsis stands out, our presentations stand out. This is one area where, as a professional, if you want to be successful, you have to work. Somebody had said very wisely, if I had more time, I would have written a shorter letter. That's what is about discarding the clutter. What should not be there, we should work on that and we should remove it. So, when I say pay attention to details, it is about thorough reading of judgments and orders. At times, I have seen people reading the operative portion of the judgment, and being satisfied with the fact that our client has won. And we don't advise the client to file an appeal. And the other person who has lost would file an appeal. Matter comes before High Court or Supreme Court. Then somewhere it is pointed out that though A was successful, there were some observations, there were some strong findings which went against A, which was never challenged at all. So, what I request is we need to read the judgments and orders very thoroughly. It is competence in action, be it a high profile case or a low profile case. Every brief is important. It's a child entrusted to us. Now, what happens is we have seen lawyers with lots of cases, and some lawyers with no cases or very less cases, and some lawyers with decent number of cases. Each may work according to their own competence. I don't say that you should not have thousands of cases. However, what I request you to consider is if an assignment is given to you, particularly after 10 or 15 years of your practice, this is what I would like to suggest for those who have crossed 10 or 15 years of practice. You must be little bit choosy is what I would suggest. Take a stock before accepting an assignment. What is the present workload that I have, current workload? Do I have time? What are the risk factors? What are the other priorities that would get affected if I take this assignment? Do I have experience? Do I have competence? Do I have expertise to deal with this matter? A client may bring an NDPS matter where I have not worked at all. If it is not that I cannot work, but if I have to work, I have to read a lot, I have to work a lot, I have to fall back on some persons who have expertise and experience in this field and then come back here. Do I have time to do all those things? That's one thing. Sometimes some people will bring 10 cases or 15 cases from one office and dump it on your table. Good. There is an NOC, no objection is taken from one lawyer and they are brought on your table and put on your table. Many a times clients may take files from your office also and give it to others. But when some cases come to you, you need to go through those files and then take a call whether it is going to affect the work that I already have. Why am I taking this upon myself? Is it worth my time, money, and energy? Again, go back to taking your stock on the availability of the time and where you need to invest your time. And that is how you take a decision. Now, another aspect that I would like to request all of you is to focus on your submissions. There is nothing known as something argument. We don't argue. It's always our submissions that matters. You can be firm, you can be assertive, but you should never be aggressive. You cannot shout on your counterpart. You don't stand up 100 times when somebody is cross-examining. You have an objection, please stand up, request the court in a voice that should be considered as voice appropriate of a professional. So what you do is you stand up and you submit. I object to this for ABCD reasons. Kindly note my objections. After noting the objections, it is for the court to do whatever the court wants to do. Firmness and assertiveness is different from aggressiveness and pouncing upon. If you raise your voice, if you are too aggressive and if you are pouncing, if you speak beyond a certain level of volume, you will never be appreciated. We are not there to enact, we are there to submit. Our submissions should always fall under two categories. One is that before we submit, we should always have an affirmation. I would rather do this. Calmness is my strength. Calmness is my strength. I always keep telling myself. Staying calm is one of the strengths of a professional. You should never get agitated. Even when something wrong is going on, you should stay calm, because when you are calm only, reasoning will start working. Without reasoning, advocates cannot work. So, staying calm is one of the essentials of a professional. And you must have comprehensive legal knowledge. It is not superficial. You don't just take the head note of a edition and come there. If possible, I would request the juniors to read it from in the court of till the end. And then you will know, supposing the judge asks, in what factual background this legal proposition is stated. You don't know about the facts of the case. You would say that about the facts of the case that I am dealing with, I am comfortable, but I have not read the entire judgment which I am relying upon for a legal proposition, and I don't know what exactly are the facts of that particular case. You will cut a very sorry face. So, comprehensive legal knowledge includes your knowledge about the facts of the case and the connection between the facts and the inference drawn and the legal proposition. That's how you take it. Your submissions may have to be tuned in the context of all these four ingredients. Now, another aspects another aspect that I request all of you to consider is, how do we consider our success? People may say Susheela is very successful because he's successful, A, B, C, D are successful from their own perspectives. And we may still find there are some insufficiencies in us and we need to work on ourselves. Success is not an end point, is what I would say. There is no end point at all. Until you die, you have to work on yourself, not on others, not on external factors. Oh, he is son of so and so. She is daughter of so and so. They are rich, they are affluent. They studied in ABCD colleges. Nothing will come. Don't depend upon external factors at all. In my book, I have written somewhere, a lotus does not worry about the pond. Lotus worries as to how it should bloom. Don't worry about the pond. You can bloom if you work on yourself consistently. And patience, I always tell my junior colleagues and others also, and in fact my mother used to tell this to me, PAP, always remember PAP, patience always pays. Be calm, be patient. Every professional will have his own time for success. When he will see that, we don't know. But once you reach that stage, if you stop there, you may fall back. Some people will maintain status quo. Some people will go forward also. I would request you to have some of the characteristics of a professional. Those essential characteristics are staying calm, having patience, persistence, and resilience. In all cases, we may not be successful. In all courts, we may not have a happy day. Some days, some clients may express their dissatisfaction with us, or some others may express their dissatisfaction with us. And sometimes we may not be able to answer all the questions posed by the court, despite we considering ourselves as the best in the field. But that should not pull you down, push you down. You should bounce back. That is what is resilience. Yes, yesterday I could not answer the queries of Honorable Mr. Judge A, B, C. but it doesn't prevent me from working upon myself. That's what is resilience about. You will bounce back. You have to bounce back. You have to learn from different sources. How successful people have taken their journey forward. That's where I tell, wherever you find time, move with successful people, ask them one or two questions. What did you do, sir? When judge said, you don't know this legal proposition, Mr. So and so, Madam so and so, this understanding of the legal proposition is completely incorrect. In such and such a case, this has been laid down, law has been laid down like this. Probably you have not touched your hands on those judgments at all. If a judge says this, how did you take this? How did you work upon yourself? These are some things that you have to learn. How do you spend your time? Where do you spend your time? These aspects you have to find out. You have to learn from different sources. Maybe from juniors, maybe some from seniors, maybe from some clients also. Introspection is one of the essential features, essential characteristics of a successful professional. I should always put this question. If I am successful in a given area or given field, and people come to me, recognizing my potential in that particular field, why are they coming to me? What is the difference that I have brought in? Could I have done something more? Can I achieve something more in this field? This is what is to be considered. Second thing is, if people are not coming to me, why are they not coming to me? Why are they not approaching me? What do I need to do? This is also that is to be considered by every professional. Should I do something more? What more I should do? How others have achieved? And if there are some course corrections to be done, we have to work on those essentials. Ultimately, it all boils down to what we have to do on ourselves. I don't say that you should not look at others. You can look at others. You can have some role models. You can take a leaf from every individual. By spending your quality time in the court, you will learn a lot. You learn lots of do's and do nots. If you see Susheela getting agitated, pouncing, you will know what not to do from Susheela. If you see Susheela being very calm, even when the situation was to such an extent that she could get irritated, then you will also learn how to maintain your calmness when the situation is completely against you. You learn do's, you learn do nots from so many people, from your friends, from your peers, from your colleagues, from your juniors, seniors, judges, court officers, bench clerks. Everyone will teach you something. You should be prepared to learn from all these people. The next point that I would like to request you to consider is, this goes to integrity. We should know our limits of control. When people come to us, they ask us, Madam, are you sure we are going to win this case? You should never say, I will definitely win this case. You can say, these are the positive aspects of your case according to me. These are the strengths and weaknesses. This you can discuss with your client or with the instructing counsel in your chambers. And you can tell that I will do my best. Whatever is to be done, I will do my best. Never give hopes on winning. Never tell them that you are going to lose that case. At every stage, you can't be winning. At every case stage, you cannot be losing. Those who are practicing before the trial courts, there will be so many IAs, there will be so many stages. Interlocutory applications will be there. And every stage you can't win. Every stage you can't lose also. So this is what is about client counseling. In my book, I have dealt in detail about how we need to tell the client about all these things. Many a times some lawyers come to me and tell, Madam, if you tell them these are the weaknesses in your case, then, and they will go away, they will run away from your office. Fine, let them go away. You need not have to give false promises to them. You can tell this is what it is, this is what it's going to be, I will do this, and what will happen we do not know. Sometimes there may be change in law, sometimes something strange may happen in between, sometimes because of the ADR, alternative dispute resolution mechanisms, in mediation or through conciliation, parties may agree on some permutations and combinations. These are all possibilities, but you don't give a false promise to your client is what we need to understand. We need to accept what is in our control and what is not in our control. When clients come with unrealistic expectations from us, we should not entertain such clients at all. ABCD things you get done, which are unethical, which are not acceptable to you, do not agree on those things. You must remain within the professional boundaries. Never cross the professional boundaries. I tell you something. Your seat, the seat on which you are sitting, is a noble seat. If the seat believes, your chair believes that this particular individual, this particular professional is dependent on me, that chair will get you all that you have to get through the profession. It may be money, name, fame, money, status, everything will come to you. Unless the chair believes that this gentleman or this gentlewoman is dependent on me, you will not be successful. So you must be devoted, you must be committed. To whom? To your profession. That profession is superior to you. When we submit ourselves to the profession will automatically bring success to us. This is what I would like to request. No assurance on result. Avoid unrealistic expectations from client. Do not feel obligated beyond professional limits. I have written a chapter on how not to identify with the clients. You can empathize with them, but it is their life, their problem. If a client's case is lost, if he loses in a court of law, you need not have to feel sorry about it. You have done whatever best you have done. If you have not counseled the client properly, if you have given him false hopes, and if you have encouraged him to have unrealistic expectations, the day on which he loses, you will lose your 2 months or 3 months of sleep. That will have an adverse impact on your other cases and other clients' cases also. That's where I request you. These are all essentials. In order to keep the client's spirit in a high level, you can't cross the professional boundaries is what you need to understand. Maybe a few days we may not get any clients coming to us, but definitely you just look at the number of advocates. How many advocates are there? Please see how many advocates are there. Hasn't profession been paying everyone? Everyone is being satisfactorily paid. Maybe somebody is getting less, somebody is getting more, but everybody is being paid. The profession will not let you down. Have confidence in the profession, and profession will take you to the next level. I think with this, I would like to conclude, and uh, I wish you all the best. I hope I'm being audible. Are you able to hear me?
Yes, ma'am.
Yes. So I am unable to see any one of you.
Just someone has said, kindly share today's PPT or permit. I would also say that you can buy the book because it's basically a sum and substance of that entire book in around 45 minutes what she has taken across. And those who have already read the previous books written by ma'am on regular second appeals and appeals, then Hindu Marriage Act, etc. you would see that she explains in a simple manner the manner in which she explains. And the manner in which ma'am has explained, I think nobody will have questions as such. And thank you, ma'am, for sharing your knowledge. We are so glad, and stay blessed. Wishing you a speedy recovery.
Thank you all. Thank you all.